Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In our previous episode of the Labour Justice Barometer, we discussed the employment of foreign nationals as a contested issue impacting South Africa's labour market and against a backdrop of rising anti-immigration sentiment. In this episode, we're going to be considering the position of migrant workers who do not have authorization to work in immigration. Immigration law prohibits the employment of irregular migrant work, yet labour law recognizes that once work is performed, rights arise. So how should the law reconcile that tension? Today, we're joined by Associate Professor Kamalesh from the University of Pretoria to unpack the legal position of irregular migrant workers in South Africa. Kamalesh specializes in labor and social security law, is an NRF-rated researcher, and serves on the steering committee of the Labor Law Research Network. Drawing on her work on foreign nationals, we'll be discussing the protections available to workers without valid work permits and why irregular immigration status does not automatically extinguish labor rights. Kamalesh, welcome to the Labour Justice Barometer. Debbie and I are very pleased to have you here.
Thank you, Debbie and Aisha, for inviting me. I'm very happy that I could be with you and talk about this very relevant and important topic.
Kamalesh, we're just going to jump straight into the questions. In your paper, you describe the tension at the heart of the debate, that immigration law prohibits the employment of irregular migrant workers, yet labor law assumes that once work is performed, rights arise. Can you maybe explain that tension for our listeners and why it has just become such an important issue?
Thanks, Aisha. So as you already indicated, we know that immigration law regulates who can enter South Africa lawfully, who can remain here, and who can work here. Importantly, there's a provision in the Immigration Act that prohibits employers from employing foreign nationals who are not legally entitled to work in South Africa. But we all know that the reality is that there are a number of irregular migrants working in South Africa. And that then raises the question, despite the fact that they are here unlawfully, once they take up employment, we've got to look at our labor laws and ask the question whether labor laws apply to them. So our labor laws, importantly, do not make employee status dependent on immigration status. So there's nothing in our labor legislation that says you can only be regarded as an employee if you're lawfully entitled to work in South Africa. And I think that this distinction is very important because while immigration law can regulate who is entitled to be and work in the country, it doesn't then follow that a person who actually performs work should be left without labor law protection. Because if we were to take that stance, it could actually create an incentive for exploitation. And we know of employers in South Africa who would employ or who do employ irregular migrant workers and then pay that person below the minimum wage or subject them to unfair conditions. And they then argue that the employment was unlawful and the worker has no rights. So the real tension is between enforcing immigration law on the one hand, while at the same time ensuring that immigration status does not become a basis for denying vulnerable workers their basic labor rights.
Thanks, Kamalesh. I'm going to follow up on that, and it's really great to have you in the recording studio. So I think there are some employers who recognize this, that perhaps workers do have labor rights, even if they are irregular migrant workers, but they're not quite sure about the nature of those rights. And you know, in your work, you've clarified this, and often the Discovery Health case comes up. So perhaps it would be quite useful for our listeners if you could give us a bit more detail on what legal protection there is and how the decision in Discovery Health case is significant.
So as I already indicated, employee status is not linked to being here lawfully or being in South Africa lawfully. And the Discovery Health case is really important because it engaged with this question of whether irregular migration status means that someone does not qualify as an employee. So just briefly, what happened in that case was that there was a foreign national who was employed and his visa subsequently expired. The employer then proceeded to terminate his employment on the basis that he was no longer legally entitled to work. He then took the employer on and lodged an unfair dismissal claim. And the argument raised by the employer at the CCMA was that because he was no longer legally entitled to work and did not have a valid he therefore did not have a valid employment contract, and he could not be regarded as an employee, and therefore he could not utilize the unfair dismissal protection. So the Labour Court rejected this argument from the employer, and the court made it very clear that employee status does not depend solely on whether there is a valid and enforceable contract of employment. The important question is, was there an employment relationship? Was the person working, and was the person entitled to be paid? So Discovery Health makes it clear that despite a person's immigration status, if there was an employment relationship, the person is regarded as an employee. And we know that once someone is regarded as an employee, that person is entitled to the basic labor protections that is provided for in our Labor Relations Act, our Basic Conditions of Employment Act. So they would have the right to lodge unfair dismissal disputes, unfair labor practice disputes, and obviously take the employer on where they were not being provided with the minimum conditions of employment set out in the BCA. And I must also say that the approaching Discovery Health is strengthened by the Employment Services Act, because this act recognizes that an employee who is employed without a valid work permit can still enforce claims arising from employment. And it recognizes that people working without work permits are in fact employees. But there is an important qualification here, because recognizing labor rights, so foreign nationals or irregular migrants who are not authorized to work in South Africa can be regarded as an employee, but this does not mean that if an employer were to terminate the services, that this would be unlawful. An employer may have a legitimate reason to terminate employment where a person is no longer entitled to work. But in doing this, the employer must act fairly and must follow a fair process. And the worker's immigration status cannot simply be used as justification for an immediate dismissal without due process. And if we consider the grounds for fair dismissal that are set out in the Labor Relations Act, I would argue that dismissing someone because they do not have a valid work permit would most appropriately fall under a dismissal for incapacity, because the reason for the dismissal is that that person does not meet the legal requirements for continued employment and is therefore unable to continue working lawfully. But importantly, this dismissal cannot be automatic. The employer will still need to follow a fair pre-dismissal procedure before dismissing the employee on the ground of incapacity.
So, although they would have access, particularly if the procedure had been unfair, of course, reinstatement wouldn't then be a valid remedy. And I suppose in some ways it resonates with the Kylie case. The one has illegality attached to the work and the other has illegality attached to the status of the employee.
I agree with that. I think reinstatement would be very difficult in these circumstances. As you said, in the Kylie case, the Labour Appeal Court did say that despite someone having recourse in terms of the Labour Relations Act, that does not mean that they would automatically be entitled to reinstatement. And in this case, or in the case of irregular migrant workers, the court compelling an employer to reinstate someone who doesn't have the authority to work in South Africa would basically be requiring the employer to commit a criminal offense. So I think in all likelihood, compensation would be the appropriate remedy should an irregular migrant worker challenge an unfair dismissal, and should that unfair dismissal be found to be unfair.
Yeah, I think I agree with that. But, so one thing that struck me thinking about it is, the circumstances of a foreign worker. You might have an employer who's given an undertaking that they will do everything in their power to renew the right to work or to pursue, some form of, and then they fail to do that. So it's almost like there might have been a legitimate expectation. But I think in those circumstances, reinstatement also wouldn't be the remedy, but there might be some recourse. But that's going down a bit of a rabbit hole. I wanted to pick up on something else you mentioned, the Employment Services Act, and its context for the employment of foreign national workers, because there have been some proposed amendments, and I think we picked up on some of these in our last episode, but it would be interesting to hear from you how you see these amendments changing the legal landscape, both from the perspective of employers and for migrant workers.
So the amendments to the Employment Services Act does not negatively affect irregular migrant workers. The amendment bill has similar provisions to the existing Employment Services Act, which I've already indicated recognizes people working without a valid permit as employees and affords them the labor law rights attached to being an employee. However, interestingly, the amendment bill goes a little bit further to say that a labor law claim by an irregular migrant worker may be enforced on that person's behalf by a labor inspector. And I think this is particularly important when we consider what happens in practice. We've seen these joint operations involving the Department of Employment and Labor, Home Affairs, and the police, which is aimed at addressing the unlawful employment of foreign nationals. The concern there is that enforcement often becomes one-sided, because when the irregular migrant worker is discovered during these raids, the focus is on immigration enforcement, which is understandable, but there should also be a labor law inquiry. Was the worker being paid the national wage? Were they being paid for all the work that they performed? Were their basic conditions of employment being respected? And the fact that the worker may have contravened immigration laws does not mean that an employer should then escape the responsibility, and that the employer should get away with labor law violations. So this is where labor inspectors have a particularly important role to play. Their responsibility is to enforce labor legislation in respect of employees, which includes irregular migrant workers. So I think this addition, which is now included in the amendment bill, it reinforces the duties of labor inspectors in protecting the rights of irregular migrant workers. I think another noteworthy amendment that we see in the amendment bill is the revised definition of a foreign national. So if you look at the current definition of foreign national in the Employment Services Act, it's defined as someone who is neither a South African citizen nor a permanent resident. So this means that the provisions regulating the employment of foreign nationals in the Employment Services Act do not apply to permanent residents because they're not regarded as a foreign national. Now, the amendment bill goes a step further by also excluding refugees from the definition of a foreign national. So this is significant because it means that refugees, like permanent residents, would also not be subject to the provisions regulating the employment of foreign nationals under the Employment Services Act. And then if we look further at the bill, we see that it strengthens the requirements governing the employment of those who do not fall within the definition of a foreign national. So if you're not a permanent resident and if you're not a refugee, based on the amendment bill, then there is stricter enforcement of the employment of such people. It provides that a foreign national may only be employed if they hold the necessary visa, or in the case of an asylum seeker, if they have an asylum seeker visa that has been endorsed with the right to work. And then the bill also places additional obligations on employers. For example, before employing a foreign national, an employer must establish that there is no suitably qualified South African citizen available to fill the position. It also gives the minister the power to introduce quotas, limiting the number of foreign nationals who may be employed in certain sectors or occupational categories. So overall, I think the bill takes a differentiated approach. It does continue to protect the labor rights of irregular migrant workers, and it places refugees in a more favorable position by excluding them from the definition of a foreign national. But at the same time, it introduces stricter controls over the employment of those who are defined as foreign nationals, which would particularly apply to temporary residents with work visas and asylum seekers who have permission to work in South Africa.
You're listening to the Labour Justice Barometer, and we'll be right back.
Another follow-up question, just in terms of the proposed amendments, there has been some negative critique, and I wonder, in your view, and with the research and work that you've done, is South Africa an outlier? Are we, aligned with our international law obligations? How do you see? It's pleasing to hear that a more favourable dispensation is being crafted here for refugees. I just wondered how you saw it, kind of holistically. I know we don't have time to go into all of the details, but your view on that.
I think from a comparative perspective, there are many countries that have laws in place that give preference to citizens and permanent residents. So I think that is the approach that is being followed in South Africa, also considering the high unemployment rate that we have in the country. So I think the bill, in a way, tries to address that as well. I think the quotas that the minister will now be able to impose, should this amendment bill be enacted into law, may create a bit of a problem, because I guess different sectors would have different demands. And in certain sectors, foreign nationals play an important role. From an international perspective, I think South Africa is compliant in terms of how they deal with migrant workers. And I think we actually have a very favorable dispensation when it comes to the protections that are provided to irregular migrant workers. In some of my research, I did a comparison with one of our SADC neighbors, Botswana. And in that country, irregular migrant workers actually don't have labor law protection. So I think that, despite the criticism that may be advanced against South Africa, I think holistically, the laws on paper are not bad.
Thanks, Kamalesh. And one of those sectors that you mentioned where, foreign workers might be play a significant role is, of course, our sector in higher education. And I wondered, we certainly here in the Western Cape had some grueling sessions with the Parliamentary Portfolio Committee around the employment of foreign academics. I just wondered how you've experienced this in your own context and what your views on and how universities should balance these competing policy objectives that you've mentioned.
The Higher Education Portfolio Committee that you were talking about didn't only deal with, the University of Western Cape. I know that the University of Pretoria was also engaged in that process. And I think that this is an area where we need to have a fairly balanced discussion. I think on the one hand, South Africa clearly has an interest in developing its own academic talent and creating opportunities for South Africans and for permanent residents to progress within the higher education sector. There have historically been challenges around transformation and the development of the next generation of South African academics. So programs such as NGAP are important because they help build the pipeline and develop the skills and the qualifications that we need within our universities. But at the same time, I don't think the issue should simply be framed as South Africans versus foreign academics. Universities, by their nature, are international institutions, and foreign academics bring scarce expertise, they bring different perspectives, they have international research networks and opportunities for collaboration. So they can make a significant contribution to the internationalization of our universities, which we know is an important objective within higher education. Therefore, a sensible balance does need to be struck. We should be actively developing South African academics and creating opportunity for suitably qualified South Africans and permanent residents. But at the same time, we need to remain open to international talent, particularly where there are skills gaps or where a particular appointment can make an important contribution to teaching, research, and international collaboration. So if the amendment bill is enacted into law, and quotas for the employment of foreign nationals are introduced within the higher education sector, I think it will be important for those quotas to take account of the particular needs of higher education. And higher education is somewhat distinctive because universities need both strong local academic capacity as well as meaningful international engagement. So for me, the objective should not be to choose one at the expense of the other. It should be to develop and strengthen our internal capacity while still recognizing the contribution that international academics can make to the quality and to the global standing of our universities.
Thanks so much for that, Kamalesh. And I mean, we've now come to the end of our episode. But before we actually wrap up, we like to ask our guests a special Labour Justice Barometer question. So, Kamalesh, if we place South Africa's current legal framework and its application governing irregular, unauthorized migrant workers on the Labour Justice Barometer, where green would reflect meaningful labour justice, orange signals partial protection, and red indicates serious shortcomings, where would you place it?
Aisha, I think I would place it in the orange category because if we look at our legislation, I think it's very progressive. As I've already explained, we offer labor protection to irregular migrant workers. And also, if we couple that with decisions that have come from our judiciary, such as the Discovery Health decision, we see that a relatively progressive approach is followed in South Africa. But when we look at what happens in practice, the picture becomes a little less progressive because we know that irregular migrant workers are an extremely vulnerable group and they may be reluctant to challenge an employer who violates labor laws because obviously they fear that approaching the authorities could expose their immigration status and ultimately lead to detention or deportation. And this vulnerability obviously makes them susceptible to exploitation. And we know employers that their there are some employers out there who would exploit this vulnerability. And that's why I think that labor inspectors need to play a much stronger protective role. When government departments conduct these joint inspections, labor laws must still be enforced. So I would say orange, because on the one hand, on paper, we have relatively strong and a progressive legal framework, but there is a gap between legal protection and effective enforcement.
I think very well said, and I would have to agree with you, Kamalesh. Debbie, what are your thoughts on this?
Yeah, Asha, I tend to agree. I do wish we could have a more sensible conversation and perhaps less anti-migrant sentiment being expressed. But I think our legal framework is a robust one, and I think with the improvements in inspection or increasing the capacity and resources of inspectors may well take us a step further and closer to labour justice.
Thanks so much, Debbie. And I wanted to thank you, Kamalesh, for actually taking the time to speak with us today. It's really been very insightful and an absolute pleasure to talk with you today. So I hope we will have you back on a future episode.
Thank you for having me. And I enjoyed participating in this podcast. As I said, I regard this to be a very important and relevant topic. And yes, maybe sometime in the future, I can join again to speak on another interesting topic.
Thanks, Kamalesh. Yes, it would be nice, Asha, actually, if we could find a topic where we're going to end up with a labour justice barometer in the green, because it gets a bit depressing with all the orange and red. Kamalesh, thanks so much for joining us. It's been great having this conversation with you. And to our listeners, we'll provide links in the episode description to the relevant materials. Until next time, Asha.
This podcast is not intended to constitute legal advice.